I am comfortable with the colloquies that were had and the
you're
decisions are
done.
made.
Here we go.
As a result of those colloquies. Just a few
I'm
matters
comfortable
right
with
now
our process. F off.
and I think I should because with some passion by Ms. Glandian. There has been some suggestion that somehow this court should not have allowed the second indictment to go forward because it was invalid, because somehow Judge Leroy Martin, chief of the criminal division at that time, when he appointed Michael Tuman, or asked Michael Tuman to be the one to preside over Sheila O'Brien's petition seeking the special prosecutor, that somehow that was flawed. That Judge Tuman, when he held hearings, and he held exhaustive hearings, and his report speaks for itself, that somehow those proceedings were flawed, and a special prosecutor never should have been appointed, and that I somehow should have been in a position to grant some kind of collateral relief and dismiss the second indictment because the appointment of special prosecutor in the first place was invalid. I've read all of those transcripts, everything that took place in all of the hearings before Judge Martin and then Judge Tuman. Judge Tuman issued his report. He took it under advisement and believing there were lengthy hearings that were held on this matter. He found that the appointment of the special prosecutor was necessary. Now, that doesn't mean that he's assuming that Mr. Smollett's guilty of something. It didn't mean that he assumed that the Cook County State's Attorney's Office was guilty of some misconduct or had done something terribly untoward or unethical. All it meant was that under the totality of the circumstances, a second look was necessary. That public confidence in this entire affair was shaken and a second look was necessary. He appointed Winston Strawn, Van Webb in particular. I find nothing wrong with Judge Tuman's reasoning, his analysis. I'm not sure I have the right to offer a collateral remedy because I'm just a trial court judge on the same level as Judges Martin and Tuman. But be that as it may, I happen to agree with their reasoning that they found that the appointment of the special prosecutor was necessary, and all they did was investigate, and then they found things after that. A report was made about the Cook County State's Attorney's Office, and obviously a second indictment came as a result of their investigation about the circumstances of the case involving the conduct involving Mr. Smollett. All right, that's that. As to
Denied.
Yeah,
when
really.
we were in COVID, this was the first jury trial that this court had, and I am an active jury litigator and have been for years and years and years. This is the first trial I was able to have since COVID, and COVID was still happening. We were under all kinds of constraints. I was told that I could only have half capacity in the courtroom, including the jurors, including the deputies, including the lawyers. I had multiple lawyers on each side. I think the defense team is 6 lawyers. Prosecution with their staff is even more. I asked the parties, how many seats do you need in the courtroom? The defense came to me at first and they said, we need 42 seats in the courtroom. It's 42 out of 57, including the jurors. I had media requests. The defense told me specifically, I asked them, do you want cameras in the courtroom? Shall this be televised? The defense said, no, we would not like it televised. The prosecution said, we don't take any position. Whatever Your Honor decides is fine. But I deferred to the defense. I understood that this is a delicate matter and preferred not to have it on television. So I agreed. There shall be no television. I did the best I could to have a public trial. We did things that we don't normally do. We kept the doors open. We had seats outside the doors that were open. We had seats set aside for the media because I knew that the media would be making this as public as possible. We did have people coming to the courtroom, and ultimately, and there was no limit on the amount of people that were here as family and supporters of Mr. Smollett. So I am confident that I did.
I'm not persuaded you didn't have a public trial.
Constitution requires. We were under severe limitations based on.
That was one of their claims. We didn't have a public trial. Wow, the audacity.
The accomplice instruction. There's been a lot of talk about this, and I did take this seriously at the time when it was brought up. We have to remember
not today.
Why we were here. Mr. Smollett was indicted for filing a false police report, felony disorderly conduct. Everything about what happened between he and the brothers, the plan that the jury found happened, the scheme to meet on the street and pretend to beat him up and call him names and do the things that they did, none of that's a crime. There was, because Mr. Smollett was consenting to it, not only consenting to it, he had orchestrated it, according to the evidence. There's nothing you could find the brothers guilty of. They didn't commit any crime. The only crime that was at play in this entire scenario was the false police report. When the police were called, the brothers were no longer there. They weren't consulted. They were out of the picture. The problem that Mr. Smollett has, or what he said to the police and what the jury found that he said to the police, and that it was patently false. That was the problem. And the brothers had nothing to do with that. And because the crime at issue was the filing of the false police report, the felony disorderly conduct counts, I found that the brothers had nothing to do with that portion of it, and the accomplice instruction for those reasons would not lie.
Yep.
And so I just want to put that to rest. And we talked about that previously, and I know Ms. Glandian is serious about it. That's fine, but I see no problem with that. As to the rest of it, we've talked about this for 2 years, and I have made records both orally and in writing on each of these issues, even some things that were not raised orally today. I'm going to stand by my findings and rulings. I do believe at the end of the day that Mr. Smollett received a fair trial, that he was proven guilty beyond a reasonable doubt by the jury based on the evidence that was presented, that there was nothing unconstitutional about these proceedings. His motion for post-trial relief was respectfully denied.
Outstanding.
Further, I'm suggesting we take a short recess.
I think
No, at this point, I'm kind of with him, to be honest. I'm kind of with him.
That the reason he gave her unfettered time to go on and on is that she would not have he would not create an appealable basis for her to claim, well, didn't have a chance to be heard. So if I just let her yammer and yammer and yammer on everything that and vomit it all out, she has nothing left to say that, like, well, she didn't have a chance to be heard. I think that's why he gave her carte blanche to just talk as much as she wanted.
That's fair.
See, if lead attorney had just hung out for a few more minutes.
Recess. We almost sentenced someone.
Have they made the actual sentencing argument?
No.
Not even touched
We've
it
all
yet.
been sentenced, but he hasn't.
Why did they,
So silly. Why would we get there already?
why did they combine the JNOV argument into the sentencing hearing? That's weird to me. I don't know. Maybe we do it different.
No, what's happened so far is I popped in because I said, this will be an efficient, tight hearing. I can get in and out. I can get back to work.
JNOV, motion for new trial, all denied, break, and then we're going to have all the arguments over what the sentencing should be. So the defense is going to have their, stuff in mitigation. The prosecution, I imagine, won't have anything in aggravation. They'll be like, this is what it should be. And maybe impact statements. Are you going to have officers from the city of Chicago come in and say, I missed hours of sleep and births and time with what's going to be the impact statements? What do you guys think?
The best version would be a police officer to come in to say that there was a crime he could have stopped, but that he couldn't because he was distracted by Juicy Smollett.
That'd be good.
Resources, you could have a financial person come in.
They could come in and say that they've received death threats and hate mail for their prosecution of
their kids are harassed at school because their daddy's a racist.
Yeah, that'd be good stuff.